Hello everyone, welcome to the U.S. Immigration Hub. After months of silence and slow movement across family-based immigration, the Supreme Court has agreed to fast-track a major immigration case that could directly affect how quickly families reunite, how long petitions take to process, and how much power USCIS, the NVC, and U.S. embassies have when reviewing family-based green card filings. For countless immigrants, this is one of the first meaningful signs that someone at the highest level is finally stepping in to address the long delays, inconsistent rulings, and growing backlog families have been facing. In this video, we'll look at the Supreme Court's decision to fast-track this important immigration case, how it could impact family-based green card processing, and why this development is raising hopes across the immigration community in November 2025. If you're liking this video, please hit the bell button, subscribe, and like it so that you may get updates straight to your smartphone. Now, let's get into the video. The Supreme Court rarely fast-tracks immigration cases, especially those dealing specifically with family-based petitions, but this time, the court has accepted a request to speed up a case that challenges how immigration agencies handle long delays, inconsistent interview practices, and verification standards that many attorneys believe have created unnecessary hardship for families. While the exact arguments of the case are still unfolding, what's clear is that the court sees the matter as urgent, highly impactful, and worth resolving sooner rather than later. This decision comes at a time when family-based immigration has been under tremendous pressure. Over the past year, the Trump administration has pushed for tighter rules, more intensive background checks, and stricter financial requirements for sponsors. This has caused families to wait longer for I-130 approvals, longer for I-485 interviews, and even longer for consular appointments through the NVC. Many immigrants have felt that the system has been slowly grinding to a halt, with some cases staying stuck in actively reviewed status for more than 18 months. Now, with the Supreme Court stepping in, the immigration community is watching closely to see whether the court will challenge or limit some of these delays. One of the central issues is how much authority agencies like USCIS and the State Department can exercise when deciding how long to place a case on hold, how aggressively to question couples, and how much evidence to demand before approving a family-based case. If the Supreme Court rules that agencies have gone too far, we could see a meaningful shift in processing timelines. Families might see fewer requests for evidence, shorter delays for marriage-based green card interviews, and smoother movement from USCIS to the National Visa Center. Immigration lawyers say a ruling in favor of families could require agencies to reduce discretionary delays and stick more closely to reasonable and predictable timelines. This matters because USCIS has been struggling with growing backlogs. Over the last few months, processing times for I-130 petitions have stretched to 12 to 16 months for immediate relatives and up to 20 months for some family preference categories. Meanwhile, NVC has been dealing with its own challenges: slow document review, long waits for interview scheduling, and increased administrative processing at embassies worldwide. For example, consulates in Manila, Mumbai, Ciudad Juarez, and Montreal have all faced overwhelming demand. Applicants have been waiting months, sometimes years, after becoming documentarily qualified at the NVC. Families have been pleading for consistency and faster processing, but without any real structural change, progress has remained slow. This is why the Supreme Court's fast-track decision is so important. When the court chooses to intervene, it often signals that the system may be violating statutory timelines or acting beyond its intended limits. Legal experts believe this case could address whether USCIS can indefinitely delay interviews, whether embassies can keep cases stuck in administrative processing without explanation, and whether families should be given clearer, more enforceable rights to timely decisions. There is also talk that the court might look at the interplay between the visa bulletin and agency discretion. Some attorneys believe the court may consider whether long-standing family preference backlogs are being worsened by internal agency practices. Another dimension of this case relates to constitutional protections. You see, several immigrant advocacy groups argue that the government's prolonged delays in family reunification violate due process and harm U.S. citizens who are sponsoring loved ones. They claim that families are being pushed apart, not by law, but by administrative inefficiency. Now, the Supreme Court may have the opportunity to decide whether citizens have the right to a timely, consistent, and transparent immigration process when sponsoring spouses, parents, and children. This development also comes during a period of increased enforcement under the Trump administration. Deportation operations have expanded, background checks have intensified, and financial rules for sponsors may soon become stricter. These shifts have put more pressure on families to navigate the system carefully, and delays have made the journey even more stressful. A Supreme Court ruling could provide balance, introducing limits on agency power and helping families move through the system without unnecessary barriers. It could reduce the uncertainty that many families face when their case is transferred, when interviews are rescheduled, or when consulates apply different standards in different countries. For now, USCIS and the NVC are preparing for the outcome. Whenever the Supreme Court takes up a fast-tracked immigration case, agencies typically begin reviewing their internal procedures. There's some speculation that USCIS field offices may start pre-adjusting policies to avoid being overturned. NVC may also prepare to streamline its communication with consulates, and embassies might brace for changes in how administrative processing is monitored or limited. As families wait for the next steps, it's important to stay informed and prepared. Applicants should continue to monitor their USCIS accounts closely, make sure that all documentation is updated, and respond quickly to any requests from the NVC or consulates. Even small actions, honestly, can help prevent delays while the agencies navigate legal uncertainties. Immigration attorneys are advising families to be patient but hopeful. Supreme Court intervention is rare, and when it happens, it often leads to clearer rules and stronger protections. Whether the court ultimately rules for or against the current system, the fact that the justices chose to fast-track this case means the issue is now being taken seriously at the highest level, and that alone brings a sense of relief. As of November 2025, all eyes are on Washington. A decision in this case could land within months rather than years, and if it brings greater transparency, fairness, and consistency to family-based immigration, it could change the immigration landscape in a way families have been waiting for. That's all we have for this bulletin. The U.S. Immigration News Channel provides all necessary visa information and procedures for your U.S. immigration journey. It's important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas such as B1 and B2, work visas like L1A, L1B, and H1B, student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, and EB5, and family immigrant visas. If you haven't already,